Dear learners, welcome to this session on the concept of affirmative action and Indian judiciary. In this segment, we will try to understand the concept of affirmative action and the conceptual debates on sameness, equality, protectionism, paternalistic approach within the legal philosophy towards women's issues. We will try to understand this with reference to few case laws. Systemic disadvantages and affirmative action. There is this case which is important. Why? Because here court has given reference to this equality clause or equality code. In State of Kerala versus N.M. Thomas, Supreme Court observed it is platitudinous constitutional law, meaning thereby fundamentally accepted broad legal principles, that Articles 14 to 16 are a common code of guaranteed equality. The first laying down the broad doctrine, Article 14, and the other two, 15 and 16, applying it to sensitive areas, historically important and politically polemical. Article 14 deals with right to equality. We discussed this in the last session, and the difference between the formal and substantive equality, which we will be doing in detail here in this session. Whereas Article 15(1) specifies, so 14 states that state shall not deny equality before law or equal protection of laws to anyone within the territory. 15 actually substantiates the idea of equality with the idea of non-discrimination. So it specifically deals with prohibition on discrimination. So 15(1) specifies that state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. 15(2) provides that no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition. With regard to, then we have these two subclause. One, access to shops, public restaurant, hotels, places of public entertainments. And B, the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. So this was the specific provision under Article 15, Clause 2. It is understandable that Article 15 is about non-discrimination very specifically. But then when we come to the different clauses under 15, we get to see that this non-discrimination, the idea of non-discrimination, is also being associated with another idea, and that is positive discrimination. Kalpana Kanabiran, in her work Tools of Justice, Non-Discrimination and the Indian Constitution, she claims that the definition of discrimination adopted by the Constitution of India can be grasped, can be understood from the text of the first two clauses of Article 15, which guarantees non-discrimination. And here she makes a distinction between vertical non-discrimination and horizontal non-discrimination. So she says that clause 1 of Article 15 speaks to the vertical application of the right to non-discrimination. When we talk about this vertical application of the right to non-discrimination, we are actually entering into the domain, the interactions that take place between state and citizen. Then we have clause 2 of Article 15. And according to her, this is about horizontal application of this right to non-discrimination. That is, between citizens. It means that it prevents people, it prevents private actors discriminating against each other. When we talk about the first one, the vertical non-discrimination imposes an obligation on the state, on governments, public authorities, and state-owned entities to treat all individuals equally, and thereby preventing the state to frame laws which are discriminatory or formulating and implementing policies which disadvantage people. Now we need to understand this point, which is very important, that discrimination is being prohibited. But when we talk about denial of liberty, then the denial of liberty is that starting point, is actually the very first step which leads to various forms of discrimination. And it provides the socio-political context, because when we say denial of liberty, we need to understand where is it being placed, where is it happening. We need to situate it within the context, within the socio-political context, because in different socio-political contexts, this denial takes place in different ways. Crucial to examine what kind of approach is being adopted by the courts when the issue comes before the courts, be it the district court or the high court or the Supreme Court. And when we talk about this violation of fundamental rights, we know that under Article 32, one can directly approach the Supreme Court of India, and then under Article 226, an individual can go to a specific high court within the country. So here we need to understand, we need to examine the approach while dealing with various forms of discrimination against women. Because the petitioners, they bring forward their petitions, and in a number of case laws, we find that different laws, different legislations, different provisions different laws are being challenged as violating the fundamental rights of the citizens, as violative of Article 15, Article 14, and Article 16 of the Constitution. So when it comes specifically to Article 15, we have, after 1 to 3, we have another clause, different other clauses. So from clause 3 to clause 6 of Article 15, the focus again shifts from the individual to the state. We were on this horizontal non-discrimination taking place, where the focus was on private actors, on citizens, and they were being prohibited from discriminating against each other. Now, when we come to clause 3 of Article 15, what do we find? That this is a very special right, a very special provision where state again comes into play, because state has been granted under these clauses the special power to make special laws not only for women and children, because children is also being clubbed here, but also for socially and educationally backward classes, scheduled castes, scheduled tribes, and economically weaker sections. Objective of the concept of affirmative action. So here the intent is not to give special rights, not to create special privileges, but the intent lies in the removal of historical disadvantages, structural systemic barriers. And then, when these disadvantages will be removed and level playing field will be provided, it can be said that equality is actually being practiced. It is in practice. And when we say this, then we do need to take into consideration the debates on equality. And these debates can be understood in terms of this sameness versus difference approach within the legal philosophy. So the first one, that is the sameness approach, which falls in line with the formal equality approach, it gives emphasis on treating men and women in the same manner, assuming that identical treatment yields equal results. However, this formal legal stance, this stance of formal legal treatment, it doesn't take into consideration, it fails to take into account the physiological, the biological differences, and also the systemic disadvantages, social disadvantages that women face. And as a consequence, inequalities get perpetuated by ignoring the real systemic issues, the real systemic hurdles. When we come to the other approach, that is the difference approach, what do we find? That it takes into account the substantive inequalities. And the focus lies here more on the impact, on the outcome of a particular policy, of a particular initiative that has been taken up by the state, rather than on the treatment. Positive discrimination, or the concept of affirmative action, aligning with the substantive approach, seeks to address the social, economic, educational, and political disadvantages that women have historically faced. It recognizes the fact that women have often been excluded from decision-making processes, and it's not only women, but there are other marginalized groups also being excluded from decision making processes, from opportunities, be it opportunities in the sphere of education or in the sphere of employment, equal opportunities, substantive opportunities, or when it comes to the leadership skills or leadership positions, there also we find the same pattern. Consequently, what is being done and what needs to be strengthened is the fact that special measures are being taken up and are considered as necessary to create this level playing field among the actors, social actors who are differently situated in the society. When it comes to their social positioning, we find huge disparities, and here, through the concept of affirmative action, the objective is to address those disparities and to remove those, to eliminate those disparities. Through this creation of level playing field, the objective is to promote women's participation, not only their representation, but their effective participation in the public sphere, in the decision-making bodies, so that they can register their voices and their concerns can be heard and can be accommodated when the policy formulations are being done. One of the most significant applications of this article, especially Article 15, Clause 3, is reflected in the 73rd and 74th Amendment Act. When we got articles, especially 243D and 243T, providing reservation for women in panchayats and in municipalities. These provisions have significantly increased women's representation in local self-government institutions, and then the objective was to strengthen grassroots democracy. Apart from this, we do have provisions like maternity benefits, workplace protection, labor welfare measures, and other women-centric welfare schemes and strategies and measures which are based on this constitutional commitment to substantive equality, to substantive outcomes. Such measures recognize the specific needs and challenges faced by women and seek to create conditions that enable their social and economic inclusion and empowerment. Coming to the case laws, coming to the standpoint adopted by Indian judiciary, we find an evolution in the approach of Indian judiciary. So there are a number of few landmark cases, and one of those cases is C.B. Muthamma versus Union of India, when the Supreme Court addressed the issue of employment and the discrimination taking place within the sphere of employment. So there were different rules, Rules 18.4 and Rule 8.2 of the Indian Foreign Services recruitment, seniority and promotion rules, stipulating certain conditions. And one of the conditions was, no married woman shall be entitled as of right to be appointed to the service. And another one was that women were required to obtain written permission. They were required to take this permission from the government before marriage. And it also mentioned that at any time after marriage, a woman member of the service may be required to resign from the service if the government is satisfied that her family and domestic commitments are likely to come in the way of due and efficient discharging of duties. So these provisions were challenged by C.B. Muthamma, who was a senior member of the Indian Foreign Services, as discriminatory, as ultra-vires of Article 14 and 16 of the Constitution. The Supreme Court upheld these contentions which the petitioner has made and declared that these provisions were discriminatory and obviously as violative of Article 14, 15 and 16 of the Constitution, and thus struck them down. So we see here in this case, and this is one of the landmark cases, that the principles of equality and non-discrimination was upheld by the court, and women employees were treated at par with men employees. Then we have another important case. So there are a number of case laws, but here we'll be taking a few. A.M. Shela versus Chairman, Cochin Port Trust, In this case, the question for consideration was whether the policy of the Cochin Port Trust to exclude women from employment as shed clerks due to the hazardous nature of the duty, whether this exclusion is violative of Article 14-15 of the Constitution of India. Here it was argued on the behalf of the respondents that the work of the shed clerks involved hazardous work, one which was just mentioned, and the presence of shed clerk was required not at the office but at various other places in port, depending upon the place where the cargo has to be handled. So the isolation and the safety of women employees was also one of the concerns. The question argued was whether this exclusion of women from employment as shed clerks, in the circumstances of physical strength, nature of work, sensitiveness of their sex, and social factors, was violative of Article 15(1) of the Constitution. It was held by the court that the policy of the Port Trust here, which is being challenged in this case, does not violate Articles 14 and 15 of the Constitution of India. Why? The court gave this reason. The differential treatment of women in the matter of employment as shed clerks is based on the nature of the work, the hazards involved, and the need to protect them. It is therefore not based only on sex. Secondly, the policy of exclusion of women from employment as shed clerk is designed to protect them from the hazards which has already been referred to. So here we find that there is this protectionist approach which was being adopted by the court, where women, it is being considered that women are there, they exist as vulnerable groups, and due to their vulnerabilities, they need special protection. Then we have another important case, R. Vasantha versus Union of India. In this case, writ petitions were filed challenging Section 66(1)(b) of and the other related provisions of Factories Act, prohibiting the employment of women in factories during night shifts between 7 a.m. and 6 a.m. So this was one of the provisions which had already been there. R. Vasantha, who was an employee and who was willing to work in night shifts, was barred due to this statutory restriction. In the case, court held that women cannot be excluded from employment during night shifts when they are being employed in the same factory during the 2-day shifts, and the denial of employment on the sole ground of sex is violative of Article 15 and it is discriminatory and therefore unconstitutional. As a result, all the writ petitions were allowed, and court also framed welfare measures. This is important, that instead of restricting or barring women from being employed during the night shifts, the court imposed this duty on the employer and adopted certain special measures, such as the duty of the employer or other responsible persons at workplaces or institutions to prevent or deter the commission of acts of sexual harassment. So during night shift, what special provisions can be taken up, what special measures can be taken up to ensure the safety of women workers? This was being held by the court. And here we see, this is very important because now we find a shift. We see a shift in the approach of the judiciary. So in case of A.M. Shella, and there are many such cases, many other cases as well, where the Indian judiciary has adopted this protectionist and in some cases paternalistic approach as well, where the state has shown its benevolence and women as a group were seen as vulnerable, to the equality based approach, where now it is being rejected and the same ideology was struck down in case of R. Vasantha. So when it comes to the idea of affirmative action and Indian judiciary, one needs to take into consideration the evolution in the approach of the judiciary that had happened during the last few decades. Thank you.